Hello and welcome to BYJU'S Exam Prep IAS. Welcome to our daily The Hindu analysis. Before we begin, let me wish all the incredible women out there a very happy Women's Day. The International Women's Day is marked on the 8th of March every year to commemorate the cultural, political, and socio-economic achievements of women. It is also a focal point in the women's rights movement, which brings attention to issues such as gender equality, reproductive rights, women's participation in the workforce, and as well as violence and abuse against women. The concept of a Women's Day originated in Western countries, particularly North America and Europe, as women started getting voting rights in the early 1900s. The idea was also rooted in the labor movements of North America and Europe, and in places such as New Zealand and New York City, Women's Day was being marked from the early 1900s itself. But later, in socialist and communist countries, Women's Day was marked on the 8th of March to commemorate the gaining of voting rights for women. But it was only in 1977 that the 8th of March was accepted and adopted by the United Nations as the International Women's Day. To mark this occasion, the Hindu carries two important columns on page number 6 and page number 7, and both examine the participation of Indian women in our workforce. Before we get into these articles, first let's examine a few important statistics. Over the last few years, India has been reporting an alarming trend of retreat of women's participation in our workforce. The female labor force participation rate, or the FLFPR, which is a key indicator, has fallen from 30.27% in 1990 to just around 20.8% in 2019, according to data from the World Bank. A study conducted by the International Labour Organization in 2018 pointed out that more than 95% of India's working women are from the informal sector. Post 2020, it is almost certain that the pandemic has further aggravated the crisis, as many women have been driven out of the workforce due to loss of jobs both in the formal and informal sector. This general decline of women's participation in the workforce is definitely a concern, and the biggest impact of this would be felt by those women who are working in our informal sector. Informal sector, which includes domestic work, construction, and other forms of manual daily wage labor, is known to be a labor intensive and low paying sector. Plus, the women who work in these informal sectors, they are often forced to work in highly precarious and hazardous conditions, which could directly affect their physical and mental well being. Upon this, women working in the informal sector do not enjoy any social security or social protection, which further affects their overall welfare as well. This notable decline of women's participation in our workforce has been the steepest during India's years of high growth, which was registered between 2003 and 2011. Now, this is ironic because as the Indian economy was booming, the benefits of this growth and development did not flow equally to women, thus clearly highlighting the gender inequality and disparity in our workforce. As mentioned earlier, the pandemic would definitely have further aggravated this crisis because several studies have pointed towards significant loss of jobs in the informal sector, particularly for women. And even data from the formal sector is not very encouraging because women's share in new payroll additions has been showing a downward trend for a long time, and it has fallen below 20% as of August 2020. So the declining number of women in our workforce and the various challenges they are forced to face as a result of their gender and as a result of gender discrimination in our society highlights the need to focus on gender equality and women empowerment. See, the theme for this year's International Women's Day is Gender Equality Today for a Sustainable Tomorrow. But however, one look at the statistics shows that this goal is still far away, and hence there is an urgent need for the government to focus its labor policies on improving the participation of women in our workforce and to provide better benefits and social security, particularly for those women who are working in the informal sector. A WHO report says that Women's informal work is central to the feminization of poverty. It essentially refers to a trend of increasing inequality in living standards between men and women due to the widening gender gap in poverty. As women are more involved in informal work, which includes domestic work and household chores, and as they are pushed by the society to just focus on family care and childcare, it results in a significant gap in the living standards of women and men, which leads to the feminization of poverty and increasing gender inequality between men and women. This phenomena largely links to how women and children are disproportionately represented within the lower socioeconomic status community in comparison to men within the same socioeconomic status. Causes of feminization of poverty include the structure of family and household, employment, sexual violence, education, and as well as climate change and healthcare. The traditional stereotypes of women remain embedded in many cultures that restricts income opportunities for women and also restricts their community involvement. As women are generally discouraged from taking up income generating jobs, and as they are discouraged from setting up businesses, it results in a significant gender gap with regard to living standards and poverty levels. In this context, it's very important to protect those women who are involved in informal work by offering the right kind of maternal and child care so that inclusive and equitable benefits could be delivered to women as well. In this regard, India is actually way ahead of even some advanced countries because the policies of successive Indian governments has given sufficient focus and attention to maternal health care and child care. India has actually taken a big stride towards institutionalizing maternal health benefits. And for example, if you look at the Maternity Benefit Amendment Act of 2017, India has provided for 26 weeks of paid leave, along with mandating employers to provide for creche facilities, all of which goes a long way in promoting maternal health care amongst pregnant women. But however, these institutionalized maternal health benefits are largely limited to the formal sector, which constitutes less than 5% of the women workforce in India. Hence, it becomes important for the government to focus on other schemes and policies as well, which can target women in the informal sector as well. And this is where schemes like ICDS, Janani Suraksha Yojana, the National Food Security Act, and the Pradhan Mantri Matru Vandana Yojana can make a real difference. Schemes like ICDS or Integrated Child Development Services are crucial for delivering maternity benefits and childhood care as it focuses on health care for both mother and the child and as well as on nutrition and early education. So such schemes will have to be further expanded to increase coverage and suitable changes will also have to be made to ensure maximum coverage of women working in the informal sector under the ICDS scheme. The early childhood care and education aspect of ICDS will have to be further converged and integrated with the objectives of the National Education Policy of 2020 in order to reduce the burden of early childhood care and education on working women. To further make it easier for working women, especially in the informal sector, the government will have to look towards revitalizing the National Creche Scheme, which has been implemented very poorly over the years due to low funding. So, with additional and dedicated funding for such schemes, the government can revitalize the national creche network, both in the public and private sector, and create public creches at the community level and as well as at construction sites, so that women working in the informal sector have easy access to these childcare facilities. Then, as childbirth and childcare is also financially stressful for these women, the government can make use of schemes like National Food Security Act and the Pradhan Mantri Matru Vandana Yojana to provide additional nutritional benefits and cash transfers, which can help in easing the financial burden on working women, particularly in the informal sector. The other article on page number 7 argues that the women workforce are in for a major transformation with the widespread adoption of digital technology. As the adoption of smartphones and internet has gone up, it has created numerous opportunities particularly in the gig and platform economy. This refers to mobile applications based contract work, which is often offered as a freelance service. Examples include popular applications like Uber, Ola, Swiggy, Zomato, and the others. So the writers here suggest a similar gig and platform model for personal health care, which could open up tremendous opportunities for women, especially for nurses and midwives. As the need for healthcare goes up significantly, especially for the sick and the young, and even for the elderly population, there is a tremendous untapped potential in the gig and platform sector where mobile app based tech companies can create high paying job opportunities for these women, which could help in transforming the lives of millions. It would not only help in streamlining the personal healthcare sector, but will also bring in numerous job opportunities. And to realize this goal, the government will have to work with the tech platforms to create the right opportunities for healthcare specialists to further improve their employable skills through better training and skill development. And the same model could be tried out in various other sectors as well, where women participate in the workforce in large numbers. For example, in the cosmetic and beauty industry, then even in online teaching, cloud kitchens, and as well as for domestic work, the gig and platform model could be tried out. And with the right institutional support from the government, these platforms are likely to succeed, thereby bringing numerous opportunities to working women, both in the formal and informal sector. Through this model, the government can also ensure better social protection and social security by mandating these firms to provide for insurance and healthcare benefits, along with maternity health and pension benefits. Now let's take up a column from page number 6 that deals with the topic of sealed cover jurisprudence. See, sealed cover jurisprudence refers to a judicial practice where the Supreme Court or the concerned courts can accept concealed information from the government agencies and the authorities in sealed envelopes related to a particular ongoing case. And based on this concealed evidence provided by the government in a sealed envelope, the judges can make a decision and even pass a ruling without revealing the contents of the sealed envelope. The confidential information or evidence contained in such sealed envelopes can only be accessed by the judges. And even though there is no specific law that defines the doctrine of a sealed cover, it does have a legal basis under Rule 7 of Order 13 of the Supreme Court Rules, and as well as under Section 123 of the Indian Evidence Act of 1872. This rule states that the Chief Justice of the Supreme Court or the judges of the concerned courts can direct certain information provided by the government agencies and authorities to be kept under a sealed cover, as this information or evidence is considered to be of confidential nature. No other party involved in the case and neither the public would be allowed access to this information, and only the judge himself gets to take a look at the information present in the sealed cover. And if the other parties involved in the case or if the public has to gain access to this, they need to seek permission from the concerned judges. The rule also states that the information can be kept confidential if its publication in the public domain is not considered to be in the interest of the public. So if the court determines that such information is not in the interest of the public, then the court can order the information to be kept confidential. And based on this concealed evidence provided by the government in a sealed cover, judges can even pass rulings and judgments. The Indian Evidence Act provides further protection for this, as it states that official unpublished documents relating to the affairs of the state are protected, and a public officer or a government authority cannot be forced to disclose the contents of these documents. Then government authorities can also seek secrecy or confidentiality for such evidence presented to the court if its publication is seen to impede an ongoing investigation, or if it contains sensitive details of the case related to the case diary of the investigating officer or related to the privacy of an individual. Now, this practice of accepting evidence from the government in a sealed cover has been practiced by the Indian judiciary both at the level of the Supreme Court and as well as at the level of lower courts. Here, I have provided a few major cases in which sealed evidence was accepted by the courts, based on which judgments were also passed by the Supreme Court. For example, in the corruption controversy involving the Rafale fighter jet deal, the government provided confidential information and evidence in a sealed cover and cited complete immunity from any public disclosure by invoking the provisions of Official Secrets Act and secrecy clauses contained in the deal between India and France. Based on this confidential evidence provided by the government, the Supreme Court even delivered a judgment in the Rafale case. Then, with regard to National Register of Citizens or NRC in Assam, which was monitored by the Supreme Court, the court had directed the NRC coordinator to submit periodic reports on the NRC exercise in a sealed cover, the contents of which could neither be accessed by the government nor by the petitioners or the public. Then, in a corruption controversy involving senior officials of the CBI, the Supreme Court had asked the Central Vigilance Commission to submit its preliminary findings in a sealed cover, and the contents of this evidence was never made public. Then, even in the 2014 BCCI reforms case, following allegations of match fixing and spot fixing, the probe committee of the BCCI submitted its report in a sealed cover to the Supreme Court and asked for confidentiality of this evidence, citing that the report contains the names of few cricketers who were suspected of involvement in match fixing and spot fixing. Then, in the recent Bhima Koregaon case, in which several social activists have been arrested under the Unlawful Activities Prevention Act on the charges of terrorism, the Supreme Court had based its rulings on sealed evidence, which was submitted by the Maharashtra State Police. While this practice of accepting evidence from the government in a sealed cover, which is not accessible to anyone except for the judges, is considered as a normal judicial practice, in the interest of confidentiality of the information, which is usually cited on the grounds of national security or to prevent impeding an ongoing investigation. So, this practice of passing judicial judgments based on evidence cited by the government authorities in a sealed cover is referred to as sealed cover jurisprudence. But this practice has often been criticized by several legal experts and constitutional experts, as they point out that this practice is not in favor of principles of transparency and accountability and puts a question mark both on the Indian judicial system and as well as on the executive, that is the government. Ideally, in a democratic state where you have an independent judiciary, courts are expected to function in an open manner where their decisions and rulings are subjected to public scrutiny and debate. But these principles of transparency and accountability stand violated if evidence from the government is accepted in a sealed envelope. It has also been argued by experts that this could increase the scope for arbitrariness in court rulings and judgments, because generally in an open court, the judges are supposed to explain their reasons and the logic behind their judgments while passing their decisions. But this cannot be done when the judges are accepting evidence in a sealed envelope which provides for complete confidentiality. So, in such cases, the reasoning of the judges behind the judgment and the decision will not contain the complete picture, as crucial evidence would be kept away from the public under the name of confidentiality. It has also been argued that whether the state should be provided such a privilege to submit information and evidence in secrecy and in confidentiality, when we already have provisions such as in-camera hearings or closed hearings to deal with such sensitive information. Plus, this practice could also violate the principles of natural justice, especially for the accused parties, as it obstructs their right to a fair trial and adjudication. In fact, the Supreme Court itself had ruled in the P. Gopalakrishnan vs. State of Kerala case of 2019 that the disclosure of all consent documents to the accused party is constitutionally mandated, meaning it's a constitutional right, even if the investigation is ongoing and even if the said documents may possibly lead to a breakthrough in the investigation. The article here deals with a case involving a TV channel from Kerala known as Media One, whose broadcasting license was suspended and revoked by the Ministry of Information and Broadcasting. The INB ministry had cited national security grounds while revoking the license, But this was challenged by Media One at the court on the grounds that this revocation of its license violated its right to free speech and as well as the right to free press, which is enshrined under Article 19 of the Constitution. In this case, the court had accepted evidence from the government in a sealed envelope, and it agreed with the government authorities that under national security grounds, the evidence cannot be revealed in the public domain, and it had sustained the revocation of license of Media One, thereby upholding the stand of the government. But the writers here argue that the practice of sealed cover jurisprudence in these cases is simply appalling in a constitutional democracy because it is not only obstructing the right to fair trial of the concerned parties, but it is also violating their fundamental rights, not just under Article 19, that is, right to free speech and press, but also the right to association under Article 19 itself, and also the right to equality under Article 14. Here, the writers argue that the judicial practice of sealed cover jurisprudence goes against fundamental rights and the basic structure of the Constitution, and they highlight the rulings of the Supreme Court in landmark cases such as the Minerva Mills case of 1980, which reiterated the supreme nature of fundamental rights, and that the Constitution does not give a free hand to the government to pass arbitrary orders which could violate these fundamental rights. So they call for an end to the practice of sealed cover jurisprudence, or to follow this practice with better checks and balances, because otherwise it would lead to further deterioration of principles of natural justice and could deny basic rights to the citizens. Now let's look at this article from page number 12, which examines the rising commodity prices as a result of the supply chain chaos which has been created by the Russia-Ukraine conflict. See, generally any war tends to have a disruptive impact on the global economy. If you look at previous wars fought in Iraq, Libya, and other countries, it did have a significant impact on the energy market, particularly on oil prices. Because these countries were major producers of oil, and naturally, conflicts in these countries or even in the region would often disrupt oil production and oil supplies, thereby shooting up oil prices and disrupting the energy market. But unlike these wars, the current Russian invasion of Ukraine is having a much wider impact on the global economy, and it is seen to be affecting not just energy prices, but it is having a much broader effect on the overall economy due to the massive surge in commodity prices, including key commodities such as nickel, palladium, and several other critical agricultural commodities as well. Now just take a look at this chart. It illustrates how global commodity prices have surged ever since the Russia-Ukraine war began. You can see how key commodities, including Brent crude oil, coal, wheat, corn, soybean, skim milk powder, cotton, crude palm oil, sugar, urea, and others, have shot up significantly in the first week of March as compared to their previous prices. Brent crude oil prices is surging towards the $150 mark, and even several other key commodities such as nickel, palladium, and even the prices of wheat and corn have shot up exponentially, and it is threatening to have a wider impact on the global economy, particularly on the Indian economy. See, as we discussed yesterday, the Russia-Ukraine war has led to disruptions in maritime trade due to the disruption of shipping in the Black Sea and the Azov Sea. Then upon this, Russia has been targeted with a sweeping set of economic sanctions, and many Russian institutions, including its leading banks and several Russian companies which were key producers of these commodities, have all been hit by these economic sanctions. See, for example, Russia is not only the world's third biggest oil producer after US and Saudi Arabia, but it is also the second biggest producer of natural gas after the United States. Russia also happens to be the third largest coal exporter after Australia and Indonesia, and both Russia and Ukraine are key producers of wheat and corn. Both the countries are also top exporters of sunflower oil and sunflower seeds, and they're also major producers of key fertilizer inputs such as urea, phosphoric acid, potash, etc. So these economic sanctions and disruption to maritime trade has meant a large-scale disruption to to this entire supply chain, which has sparked fears of a recession, thereby triggering a collapse in stock markets around the world, and has led to an exponential surge in commodity prices. Then Russia and Ukraine are also major producers of industrial metals such as nickel and palladium, and India happens to be a key importer of all these commodities and products that we have just mentioned. So these soaring prices, especially rising oil prices, they are bound to hit the Indian economy very hard, as it is going to shoot up India's import bill, and it will further put a severe strain on India's macroeconomic conditions. Now let's take a look at the mains practice questions. The first question: examine the challenges and opportunities surrounding the participation of women in our workforce. The second question: what is sealed cover jurisprudence? Examine its rationale and the criticism against this judicial practice. Kindly write an answer to these questions and post your answers in the answer writing portal, for which the link shall be given in the description box below. So if you're finding our initiatives to be helpful, do like the videos, share your comments, and don't forget to hit the subscribe button. With this, let's end our discussion for today. Thanks for watching.